let's assume then that we've got past all of these questions of making offers, the things still on the table, and let's look at acceptance and the consequences of that. There are two key rules that you'll want to look at. The numbering throughout has changed because we don't like 1As and all of that, and you know, the thing runs to a piece. So that's one reason. The other is the reorganization of the text. But a lot of it will be familiar when you look at these rules. 3611 is the rule that deals with acceptance. And 3613 deals with the consequences of acceptance. And I'll just highlight, if I may, what's changed. This bit superficially looks like a change, but I'll demonstrate that it's not. This is the rule that under the old rules, 36.9, there were a number of embargoes as to when you needed the permission of a judge before you could accept. One of them was the trial has started. Another of them was judgment has not been handed down. The new wording, for better or for worse, is simply that a trial is in progress. And if you went to 36.3, you would see that that's defined as from when it starts to when judgment is given or handed down. So no change. Why fiddle around with the wording, you might well be asking? Well, there are reasons that relate to what we've done with split trials, that our new wording, we think, works better. But if superficially you look at that and think it's changed, it hasn't. There is an embargo throughout the trial, throughout the course of the trial, from when it started until judgment upon acceptance. The other thing we've looked at in respect of acceptance, the previous rules didn't give any guidance on this, but what happens if I make an offer to you in respect of just liability? Or I make an offer to you, let's get a bit more subtle, in a contract case, that the correct construction of this contract is 1, 2, and 3. That's my Part 36 offer, and you accept it. What should be the cost order that flows? Should it be an issue-based order? Should it be that on acceptance of that offer, the claimant should receive the costs of liability or the costs on the construction point? Logically, that sounds right, and we flirted with putting exactly that in the rules. But the problem with that is that the rules themselves contain a sort of warning to judges about making issue-based cost orders. That's where it is. And the reasons that the cost lawyers in the room will know, it's an absolute nightmare to actually try and assess issue-based cost orders. And judges are always told that it's far better to order a percentage of costs, or maybe the costs between two dates, rather than actually to order the costs of a particular issue. And because of that, maybe it's a cop-out. At Rule 14, Rule 13, let me get it right. Rule 13 that deals with cost consequences of acceptance. On page 10, at paragraph 4, there have always been a number of circumstances where, on acceptance, you need the judge to make the cost order. That's paragraph 4. A and B, no change. But C is new, that the Part 36 offer does not relate to the whole of the claim. And in that situation, you do now need to get the judge to make your cost order unless you can agree it. Now, I would suggest that the fair and logical starting point, surely, is to think, well, what are the costs that have been incurred on that issue? So you do actually start with the issue-based cost order, do you not? And if you can reduce that to a sum of money, then great. Alternatively, you might go for a percentage between two dates or something of that sort that you think fairly reflects the issue-based costs, because that's probably the approach a judge might want to take. Now, a lot will take the lazy route, I suspect, and still make the issue-based cost order, and you might even agree it, and I'm sure the judge will rubber stamp it for you, but it does store up problems for later on. There's a small change at 3613.2. I've dealt with what it is in the notes. It's probably not of sufficient significance for me to say more about it now, but I'll happily take questions on that little tweak there if somebody has a question later on. I'm turning then to the question of late acceptance. We all know the basic rule that if you accept the offer late, the offeree pays the costs from the end of the relevant period until the date of acceptance. And we also know from the rules that there's always been, this is where it used to be, there's always been a provision that that prevails unless the court orders otherwise. Well, what we've done is we've decided to be a little bit clearer about when the court should order otherwise. And new Rule 13, para 5, tells the court it should order otherwise. It should make that order unless it considers it unjust. And we've gone a step further. We've told the judge what the test is as to whether it's unjust. This test, 3617.5, we will look at in a moment in respect of the position after trial. So I'll go through the detail of it then. But that is the rule that allows a judge after trial to make an order other than the usual costs orders on a Part 36 offer being effective after trial. And what we've done is we've said those same criteria ought to govern this. Now, that isn't actually new law. That's codification. It's codification, first of Mrs. Justice Lang, in this case, Lum and Hampsey, in 2007. And there's some earlier cases to the same effect. Most recently, actually, Court of Appeal, a case called SG against Hewitt, 2013, decision of Lady Justice Black in a severe brain injury case that the personal injury lawyers will probably know and remember, because that's got some importance to Part 36 in that particular line of work. But just codification, but at least it's now within the rules.